Hello again, everybody. The purpose for today's video is to kind of fast forward a little bit and explain uh, where we are with the dealings in the state of Ohio. Because even though I'm still in Florida, I am attempting to rectify the situation through the state of Ohio. Even though I've been told that since I'm no longer a citizen of the state of Ohio, um, doesn't matter. But I have to dot I's and cross T's in order to establish a reason for the Florida court to be able to pursue action. So here's where we are. When you're dealing with um, any legal entity, an attorney, a judge, uh, pretty much anybody that's in a capacity of a what you would call a court officer, they all fall in the state of Ohio. They fall under the jurisdiction of the Ohio Supreme Court's Office of Disciplinary Counsel. Bar Association has nothing to do with this. Was my original thought, and however, that being said, I got it on good authority through the Attorney General's office, through the state of Ohio, and the Congressman's office, different government officials that I've spoken with, as well as the FBI, local law enforcement, etc., etc. So, to get the information, I go onto the website, print out the complaint form, and fill it out. Here's the complaint form. As per the decision on 1/21/2011 to declare my right to seek custody and/or relief from judgment being declared moot has hindered my rights as a parent and ability to force Christina's participation in executing established orders by the court. It has also had a recent tragic and unforeseen effect on my youngest son, Stephen. Because Christina has been given this absolute power, she now refuses to answer the phone or allow my parental involvement with the children. And Christina is now having Stephen declared disabled due to ADHD so she can collect funds from SSI for his care. I have a sworn statement from a PhD expert witness in child development stating that Stephen does not need, nor does he suffer from this disease, and without an ability to show this evidence in court, these drugs his mother has him on are doing him serious damage. Per my expert witness, the situation these people have created for my son and I is in every way criminal and needs to be dealt with as such by a proper convening authority. It is my opinion that these people's track record in dealing with men's rights are extremely negatively biased against men and consequently adversely affecting our children. I've been dealing with these same people for almost 25 years now with the same results in every issue brought before this court. Times must and do need to change. That being said, this regime needs to go. To make way for a new generation to allow for more reasonable and equitable situations to result from this court's decisions. It is not 1955 anymore, and that formula no longer works in today's ever-changing parental and economic climates. Contrary to Pamela Rintala and Alex Savakis' line of thinking, one size does not fit all, and my repeated need to back and forth with these people is only further evidence of that fact. This decision clearly crosses lines outlined in the Doctrine of Parents Patriae, outlining the state's non-interference in a parent-child relationship. Based on my previous experience and this court's established reputation amongst its peers, a reasonable person can only conclude this court has crossed the lines of ethics, scope, and harassment of the very people it is sworn to protect, namely the children of the community. It is also very clear that your office's lack of a timely participation in this matter is only going to add to the negative effects of drugs in my child's brain chemistry. Admittedly, I am apprehensive to begin yet another round with the state of Ohio in which I can expect to be treated as a deviant or an irritant when my only goal is to present evidence and protect my children. But I'm afraid neither of us has a choice here. So I must ask you I must ask you clearly, or I must ask you something you clearly have no desire to do. That is to remove these people from position and allow me to act unhindered by outdated thought processes and old arguments. This is a new day, and we are better than this. In conclusion, I will only ask, under these dire circumstances, and as a reasonable person, what would you do? And what else is there for me to ask? I also sent an attachment to that complaint, to whom it may concern. The reason for this attachment is to make it clear my intentions are both honorable and in the best interest of justice, not revenge. I also wish to point out that I am not looking for free legal advice, nor am I asking you to litigate the current issue, but only to further express the need for proper litigation in a proper court forum, as it has always been done in the best interest of justice. As I like to consider myself to be a reasonable and open-minded person, I would like to add two more possibilities. I would consider as acceptable alternatives to the removal and prosecution of those who participated in the events outlined earlier in this complaint. Though the word moot and all verbiage associated with the word and that finding do need to be removed post haste, and once that is done, I would be open to transfer of jurisdiction to a court here in Florida, as this is the most likely where it's going to end up anyway, or transferred in the short term to the Mahoning County Court to discuss the immediate issue, and then transferred here to my local jurisdiction. Please accept my sincerest gratitude for your attention to this issue, and my hope that you see the wisdom and need for action on this request. That complaint was filed 8/20/2014. I only recently got a response, which, by the way, I was surprised to see that I actually got a response as fast as I did until I read it. Well, here it is. This is the let's see here. Chief Disciplinary Counsel Joseph Calgary, I can't pronounce his name. Dated September 30th, 2014. Recomplaint Alex Jerry Savakis. File number B4-1892J. Dear Mr. Howell, your grievance concerning Mr. Magistrate Savakis was received in our office October 21st, 2014. Please be advised that the authority of the Disciplinary Counsel is limited to investigating alleged misconduct and violations of the Code of Professional Responsibility, the Ohio Rules of Professional Conduct, and the Code of Judicial Conduct by attorneys and judges. Therefore, the only violations of specific rules governing attorneys and judges can be addressed by this office. Further, our office cannot provide legal assistance, offer legal advice, or answer questions of a legal nature. I'm going to stop right there for a second. Now, if they would have read the complaint clearly states that that was not the reason for the complaint. I clearly stated that I didn't want free legal advice. I didn't want them to litigate the current issue. I wanted them to look at the case, look at the facts, and take the appropriate action based on whatever Ohio law dictates on the basis of those actions. I'm no expert. I was referred to them by an expert. Anyway, I'll continue. Upon review of your grievance, we do not note any evidence of conduct constituting a violation of the code by Magistrate Savakis. Dissatisfaction or disagreement with magistrate's ruling of law are legal issues subject to objections and ultimately appeal. A magistrate's ruling of law, even if erroneous, are not by themselves evidence of bias, prejudice, or other ethical misconduct. Now wait a minute. Hey, never mind. You get the idea where I'm going with this, right? You have provided no evidence that Magistrate Savakis' decision has been the product of any unethical, influential, or action. It appears that he has simply made decisions with which you disagree. Duh. If you are dissatisfied or disagree with the judicial decisions made by Magistrate Savakis, these concerns should be raised with the presiding judge through the objections to magistrate's decisions process, which I did follow, by the way. If the presiding judge agrees with the magistrate's decisions, you will need to appeal to the 11th District Court of Appeals. Now that process takes years. It's not about the money at this point, it's about the years. If you want Judge Rentala removed from presiding over your issue, you will need to file an affidavit of disqualification with the clerk of the Supreme Court of Ohio, as Chief Justice O'Connor has the sole authority to remove Judge Rentala from a pending case. You would also notice that the case is not pending. The case is closed. They can do whatever they want to do. Don't let them fool you. The grievance process is not substitute for court process, nor does this office an alternate trier of fact or appellate form. It appears that you may not understand our very limited jurisdiction. Guess what? Your peers are the ones that directed me to you, so they're the ones who lack understanding, not me. However, I'll continue. The authority of this office relates to the licensing of attorneys and judges only. Our mandate is to protect citizens from unethical lawyers by suspending or removing the licenses of those lawyers to practice law. We cannot intervene in pending cases, nor can we review legal merits of any litigant's claims. We also have no jurisdiction to review a court's legal determinations or to redress alleged rights violations. This office does not reheard, whatever that means, over the justice system. Well, if that means what I think it means, your peers would seem to disagree with you there, Joe. Anyway, continue. The disciplinary process is designed to weed out unethical lawyers by affecting their ability to practice law. It is not about obtaining a particular result for a particular grievance in the underlying case that gave rise to their grievance. Talking to lawyers is like, it's like talking to kids. You gotta pull it out of them because they just don't speak plain English. Anyway, disciplinary process does not exist to assist grievance except in the sense that grievance as citizens benefit by having unethical lawyers prevented from coming into contact with affecting them through the suspension or removal of license of those lawyers by attorney disciplinary authorities. Didn't we cover this? We pursue only those cases that present prosecutable claims of ethical misconduct, i.e., that supported by substantial, credible evidence. In other words, that would involve, you actually have to, read a document or two, do a little homework. Your grievance did not present such a case. Instead, you appear to want us to intervene and change the outcome of the litigation which you are or have been involved. Please be advised that even if we determine that an attorney or judge associated with this litigation has engaged in unethical misconduct so as to subject him or her to discipline through this office, the disciplinary process would have no effect on that litigation. Nothing this office would ever do would result in the change of your child's visitation custody, blah, blah, blah. For the aforementioned reasons, we have dismissed your grievance and close our file. Now, What that is lawyer speak for, we don't care what your situation is. We're going to stand behind, our friend. We're not going to look at a document. We're not going to look at a single piece of paper and pretty much kiss our rear end. That letter prompted this response. Re-complaint response. Mr. Joseph Calgary and committee. I can't say the guy's last name. So anyway, I'm certain if you are unaware of the many offices and officials I spoke with before submitting my recent complaint against Mr. Savakis to your office, so I'll go down the list. I contacted the Attorney General's office, the Governor's office, various senators in multiple states, even every law enforcement agency I could think of, and finally, the FBI's Civil Rights Division. Every one of them referred me to you and your team as issues of ethics and judicial procedural questions are directed through your office. I have spent these few weeks trying to digest the most recent response I received from you and your team, and I must confess a certain dissatisfaction with your lack of resolve in pursuit of the facts in this situation. Or more to the point, this is by far the worst attempt at a non-answer answer to an issue that is as plain as the nose on your face, and the fact that you would take such a calculated standpoint on this is appalling. As I said in the complaint, I'm going to ask you to do something you clearly don't want to do. So I'm going to be right up front and bluntly honest with you. If your mission statement is to be believed, your office's job is to conduct reviews, gather facts which determine the truth as they pertain to established ethical and professional standards of practice. In other words, it's your job to determine what violations exist in any given situation, not mine. Let's face facts here, shall we? Ethics and professionalism waved bye-bye to these people a long time ago. And if you expect anyone to believe that this situation is anything short of judicial and government bullying, you are in for a very big disappointment. If you think people are not smart enough to see through the political agenda going on here, you are sorely mistaken. If you think that people haven't figured out that this is all about money, again, you are sorely mistaken. If you think that the corruption and evident attempts to hide the truth don't stick out like a sore thumb, you are sorely mistaken. If you think that I'm going to stand by and let this travesty of justice go unanswered, you are sorely mistaken. If you think that I lack the resolve and intelligence to expose your state's war on men and open Pandora's box for you, again, you're sorely mistaken. If you think that just because I didn't start this fight and I have no intention on finishing it, again, you are sorely mistaken. If you think I won't expose you and your team to the worst press and public opinion trial you have ever seen, starting with this correspondence, you are sorely mistaken. Let me put this another way. If you think I'm going to just go away, again, you are sorely mistaken. I must also remind you that you are dealing with a man that has no criminal record because I don't break the law. So, translation. I will plaster my son's face, videos, my PhD evidence all over the internet and every news agency in the country. And unlike Trayvon Martin or Mike Brown, who were proven guilty of crimes, so they had no staying power, my son is just a baby caught in the middle of a political pissing contest to which Stephen is the victim. Let me say that again. Stephen is the victim. That is his name, by the way, Stephen Jeffrey Howard. He turns 8 this Saturday, and I will protect my baby boy. Guaranteed. So here it is in plain English. If you think that I'm going to stand by and watch my children's mother shove drugs down his throat so she can collect more Obama money, newsflash. Working people are sick of political agendas and are looking for a face to expose political corruption. And unless you want that face to be my son's, well, you're either on my side, by my side, or in my way. At this point, I caution you, choose wisely, but choose now. Remember this simple fact. You and your team are the ones that need votes, not me. And when this all comes out in the wash, and it will, I'm the guy you will want to be standing there shaking hands with. You have until Friday, October 15th, 2014 to respond, or I go all out first thing Monday morning. Which, by the way, I did. Now, I know what you must be thinking, so I'll save you the trouble. How in the hell did we get here? The answer is in the question. Or to quote Edmund Burke, the only thing necessary for the triumph of evil is for good men to stand by and do nothing. So the only real question becomes, which side are you on? And if you doubt yourself, go take a long, hard look in the mirror, because that man always knows the right answer. I'll give you a hint. Sometimes you have to know when to move the board instead of the pieces. So do you want to be us or them? Well, their lack of response simply tells me that they're not us. They are them. And though what I just read to you it is what it is. So if you're currently going through the situation or going through anything like it, I can tell you, has nothing to do with anything to do with established law. Okay, it's not about the law. They want your money, which I don't object to. I'll pay anybody whatever they need to have to accomplish the goal. But first of all, like any other consumer, I don't want something for nothing, but I do expect to get what I paid for. So here's where we are. The attempt, as I said, the attempt at a non-answer answer is not going to fly, because during that complaint, at no time did I tell them I wanted them to litigate the current issue. As a matter of fact, I was very clear in stating that I don't want them to litigate the current issue. However, because it is what it is, jurisdiction falls within that particular court. This is where it gets tricky. Jurisdiction is, let's just put it this way. Without an act of God, you're not going to transfer jurisdiction, no matter what the UCCJEA says. And believe me, I've become quite the aficionado at it. So I will tell you this much. This person is going to lose a job. And the fact of the matter is despite what they may try to tell you, I had nothing to do with it. This is only a response to their actions. So no matter what, like anybody else, this is not my action. This is my reaction. So you want to declare what's reasonable and not reasonable? Let's start with looking at number one, where we are. Let's look at the facts. And last of all, let's put it in front of a jury. See what a jury says. Because I'll bet on a jury any day of the week, twice on Sunday. So, again, that's where we are currently with the state of Ohio. The long and the short of it is they're not going to even attempt to look at any type of a possible resolution to the situation. What they want to do is what attorneys like to do. They want to drag it on and on and on and on until after the kids are 18, and then they say, guess what? Doesn't matter anymore. And oh, by the way, you still owe us all of this money. And as I said yesterday, that's what it's all about. It's all about money. It's got nothing to do with your kids. It's got nothing to do with you. It's all about your money. And they want it because just like what the Ponzi scheme of Social Security, the next Ponzi scheme of Obamacare, because let's face it, Obamacare has nothing to do with the healthcare industry. It's insurance reform. So to call it anything but what it is, again, is yet another lie. But we'll cross politics later on in a different video and in a different form. Right now, the issue is Stephen. And I can promise you, I ain't going away. And I'm not giving up. And dads, and even moms out there who are going through this, I advise you to do the same. Never give up.